still adding just a few folks that are in the waiting room.
The thousands of people coming in.
Popular group. I do think we have most of our work group. So I will keep an eye on our waiting room here, and we can go ahead and kick things off since it's 12:03. Can everyone hear me okay? Since we had just a few audio issues. Okay, great. Well, welcome to the first meeting of our anti-speculation law work group. I am going to run through a few logistics before we get started. I'm Amy Moyer, Assistant Director for Water with the Department of Natural Resources. Before I kick things off to Executive Director Dan Gibbs to welcome the group. Obviously, we're on a virtual platform. We'll work with our technology here. Similar rules, be mindful of your mute so we can have a good discussion. Be mindful of just keeping that mute on while you're not speaking. These meetings are open to the public, so we have broadcasted the Zoom link, and we also have this live streaming on DNR's YouTube channel. And I think, Vivian, you might be able to post the link there in the chat if folks are more comfortable just listening on the YouTube platform. And then we'll continue to publicize the meetings going forward on CWCB's event calendar and make those virtual links available. And then I also just want to thank everyone for their time. I know it's yet another important topic to have some really great discussions on. And so with that, I will turn it over to Executive Director Dan Gibbs to welcome the group.
Great. Thank you so much, Amy. And welcome everyone to the first anti-speculation law work group. Really appreciate all of your willingness to participate in this really important committee. Hope you all are staying well and healthy during these challenging COVID-19 times. I wish that I could wave a magic wand and that we would all be meeting, in person here at the Department of Natural Resources, or even maybe for outdoor meeting. Who knows? The weather's so nice. But this is definitely a very important topic in Colorado water law, and I'm really proud that we have such a diverse, top-notch people to examine and explore the ways that we can currently strengthen the water anti-speculation law. We definitely have some of the best, legal minds participating in this presentation. We have representatives from the East Slope, West Slope, farming, ranching, water users, environment, and outdoor recreation. And our goal is to have a transparent and well thought out process over the next year and leading to a final report to the Water Resources Review Committee by next August. I want to give a special thank you to Kevin Ryan and Scott Steinbrecher for co-chairing this really important effort, and to my Assistant Director on Water, Amy Moyer, who will be playing a supporting role of this team over the next year. So next, I want to turn it over to Kevin to facilitate a round of introductions to you all. But again, I really appreciate your willingness to step up and be a part of this really important committee. Thank you.
Thanks a lot, Dan. And thank you, Amy, for kicking us off. I want to give a special thanks to Amy because she's done so much to help coordinate the kickoff of this work group and the important work that it's going to be doing. And Amy will be, as Dan said, such a pivotal member of this group as we work through, and she keeps us coordinated, both in terms of what we're doing, but also substantively and the direction we're going. So thank you, Amy, for that, and thank you, Dan. Again, I'm Kevin Ryan. I'm the Director of the Division of Water Resources and the State Engineer, and it's a privilege for me to be part of this group and co-chairing and co-facilitating the work we do. As I say that, I just want to remind myself and all of us that is my role to a large degree, is to co-chair and co-facilitate. It's the people that Dan has brought in from around the state that will be doing the substantive work and giving us the work product that will hold up to a report to the Water Resources Review Committee, because it was clearly the intent of the legislation that there would be important people from all around the state involved in this. I'm going to introduce Scott Steinbrecher, our co-chair, and let him say a couple things, and then I'll go down the list of the rest of the people and have them say a couple things. And I just want to make a point that I'm going to ask you to say a little bit about you, how you see your role and what's important to you on this topic. That's not just an icebreaker for us folks. That is part of you informing the rest of the group who you are, and you're going to be working together and doing a very important report together. And so I think it's good for you at this time to tell us more about yourself, since we'll all be working together. Scott, would you like to introduce yourself, please?
Yes, thank you, Kevin. So I'm Scott Steinbrecher. I am Assistant Deputy for Water at the Colorado Attorney General's Office. So what that means is that I oversee our water attorneys within the office. That includes those folks who are working day to day with Kevin and his office to enforce current anti-speculation laws, as well as those attorneys who represent the Water Conservation Board. And I also oversee attorneys who are working to negotiate or who are in litigation on our interstate compacts. So see a wide variety of views from that state perspective on water. I also advise the Attorney General on his own affirmative. Muted here. Can you all hear me again? Okay, great.
I'm trying to unmute him. I apologize.
That's okay. Okay, can you hear me again? Yeah. So in addition to representing our attorneys who are working in water courts around the state, I also advise the Attorney General on his affirmative water policy agenda, and he is sorry that he couldn't be here today to join us. So we'll have to hope that we can include him in one of our later meetings. And Kevin suggested that we all share what this work group means to us. And for me, I am very excited to tackle the challenge that has been delivered to us by this legislation. I'll explain in more detail as we move farther into the meeting, but I think we have been delivered a real challenge here to explore how existing law can be strengthened, and not to simply look at what existing law allows for. So I look forward to facilitating the group and seeing how this various team from around the state looks at the challenge and tackles exactly what the legislature has given us.
Thanks a lot, Scott. Let's move along. I want to introduce other people from the state and mention particularly that we have 2 other people from the Division of Water Resources and 3 from the Colorado Water Conservation Board, as directed by the legislation that we would have people from those 2 agencies. I can't say for sure we have everyone from CWCB today. I'll double check that. But next I'd like to introduce or have Tracy Kosloff, the Deputy State Engineer with the Division of Water Resources, introduce herself. And again, just real quickly, Tracy, a little bit about yourself and the importance of this work group to you.
Thanks, Kevin. As Kevin mentioned, Tracy Kosloff, Deputy State Engineer. One of the roles I play at DWR is leading our litigation efforts. I work with our engineers and the Attorney General's office. And that includes some recent cases that we've had where speculation has been an issue. And so I'm just happy to be able to contribute the perspective of the State Engineer's Office for this effort. I think I'll also be working on some of the drafting of the report. So look forward to it.
Thank you for that, Tracy. We also have Aaron Light, the division engineer for Division 6, the Yampa and White River Basin, also includes the North Platte. And Aaron, would you like to say a couple things?
Yes, thank you, Kevin. Aaron Light, as Kevin indicated, I'm with Division 6. I'm the division engineer there. I've been in Division 6 for many years, and for many of those years, I've been the division engineer. One thing I feel like I can bring to this group is my direct interface with the water court system. Obviously, I work very close with the water court, the referee in particular, as well as various attorneys. Additionally, in my basin, we do have a lot of conditional water rights, both existing and, of course, new water right claims. These water rights, either existing or new claims, vary from something very small to large. And I think our basins here bring good examples of, in particularly existing water rights, conditional water rights that remain on the books and have been on the books for some time and can tie up quite a bit of water. So I think I can bring a lot to the group in that regard, that I have that direct interface with the water courts.
Thanks a lot, Aaron. And we do have all our CWCB folks. Lauren, you're next.
Hi, everyone. Thanks, Kevin. I'm Lauren Riss. I'm the Deputy Director with the Colorado Water Conservation Board. And along with DWR and the Attorney General's Office, the CWCB is one of the entities that was named to the work group. I'm participating broadly just to keep an eye out for things that might affect CWCB. We have a variety of different programs that are potentially related to anti-speculation, and I'm just really eager to hear the discussion and hopefully draw in any relevant perspective from CWCB. So thanks.
Thank you, Lauren. Amy.
Hello, my name is Amy Ostick, and I'm the Deputy Section Chief, the Federal Interstate and Water Information Section at CWCB. I've been at CWCB for a little over a year now, and before that I was actually at the Federal and Interstate Unit at the Attorney General's Office, where I got to work with Scott. So my background is, law, but since I've been at CWCB, I've a lot of my work has been focused on coordinating the demand management feasibility investigation. And within that, there has been a lot of discussion and some concern about, the potential of creating a market for water and how the anti-speculation law might fit within that and interact with a program if we set one up. So I'm certainly interested to see how the discussion unfolds, being mindful of the thoughts and concerns I've heard from people across the state in the context of that feasibility investigation. So thanks for having me, and I look forward to the meeting.
Thanks a lot, Amy. And Alex, you're next.
Thanks, Kevin. Alex Funk. I'm the Agricultural Water Resources Specialist at CWCB. I also work on our Alternative Transfer Methods program and have been helping out with demand management work as well. I guess a few things, one, obviously want to make sure that if we do end up strengthening any sort of anti-speculation legal, framework, that it doesn't limit flexibility to address other water challenges facing the state, everything from interstate issues to buy and dry. Speculation seems to touch on a lot of those concerns, and want to, make sure that we're kind of thinking about those implications moving forward. And I guess the other thing, kind of coming from the ag spec, sort of perspective, and it's that, there is certainly a tension here where, land and water assets are extremely valuable to producers. In some cases, these are sort of their only asset. And so, we have to kind of be careful in thinking about, what options they have in terms of being able to maintain the value of those assets and not necessarily, kind of limit that, but also at the same time, I think some private investment in ag can be beneficial if done appropriately. So just kind of thinking about how this plays out on the operational side of things as well.
Thanks a lot, Alex. That really is the group from within the state. I'd like to move on to, as I said, the other group members that will play such an important role. I'd like to start, I'm afraid that Justice Greg Hobbs may not be on the call. Justice Hobbs, are you on right now? Okay, we'll follow up. We got word that he may not have been available this morning or this afternoon to meet with us, but I just want to quickly do my introduction of Justice Hobbs as a member of this work group. You'll note in the legislation that it called for a member of judicial to be part of the work group, to be named or appointed by the Chief Justice of the Supreme Court. And we were just so thrilled to see that that would be Justice Hobbs. I think his reputation precedes him, both in terms of understanding the history of law and the work he has been involved with on certain rulings. And so we'll certainly hear more from him. Unfortunately, he's not with us today, at least not yet. And with that, I'm going to move on to some other members that are part of the work group. And I want to start with Peggy Montano from Trout Rayleigh. Peggy?
I think I'm on now. I thought you were going to go in alphabetical order. Because that's how the participants.
Now, you should know me better than that.
I know. Thank you, Kevin. I've been taking a few notes here, trying to think about, what can I bring to the work group and what is my background. First of all, I don't know if I'm sad or happy to say that I've been doing water law for over 35 years in Colorado, did a stint in the Attorney General's office, and then have been in private practice a long time. Specifically, and then also spent a lot of time with Kevin over at the Water Congress State Affairs Committee looking at bills as they come through, some of which have been, concerned with speculation, including this one. The two specific things, and, I think being narrow and then thinking about the work of the group that come to mind when Scott called me about doing this was one, I've advised, public entities on creating rules when they had concerns about speculative interest coming into their water district, creating those rules, defending those rules when they've been challenged in litigation. And so there's that perspective. The other is for other entities defending in diligence, them keeping their water rights when there was a challenge from out-of-state water districts who would benefit if the water right was not continued and if the water court declared it abandoned and didn't continue the water right under a diligence claim. And in that respect, had to hire lots of consultants, financial experts, permitting experts, other experts to defend these entities keeping their water rights in Colorado when they were challenged from out-of-state entities. So those are two particular things that come to mind. But I want to help and think about this with the balance being that, there are a lot of reasons and probably very valid ones that we don't want to try to lock up all the resources in Colorado. So there will be a balancing, I think, to be done in this report. So those are my immediate thoughts, and I appreciate the opportunity to be a member of the group.
Thanks a lot, Peggy. Insightful comments that start to dovetail with some of the conversation we're going to be having later. So thank you for that. Next, I'd like Peter Fleming. Could you please introduce yourself?
Thank you, Kevin. And can you hear me?
Yeah.
Yeah. And thanks, Director Gibbs and others for inviting me to participate in this group. I'm looking forward to it. I am General Counsel at the Colorado River Water Conservation District in Glenwood Springs. As most folks know, the River District covers a good chunk of Colorado's west slope, four major river basins, the Yampa White, the Main Stem, Colorado, and the Gunnison. And I noted that the prime sponsors of the bill that it gave Director Gibbs this charge are all from the River District's area of the state. So I figured I'd better pay pretty close attention to this.
I've been at the River District as general counsel for, I think 18 years. I was in private practice in Denver. Prior to that for about 11 years or so. And as most folks probably are aware as well, the River District is the current site of some acquisitions of agricultural lands by investment groups that have as their, excuse me, their ultimate goal, acquiring a return on their investment, likely through the use or non-use of the water that is associated with those lands. Therefore, this anti-speculation charge here is really of keen interest to the River District and its constituents at this time. There certainly is an important balancing, I think, as folks have noted, Peggy and Alex before her. But I think there's some important digging to be done as well with respect to what existing law already provides, or a logical extension of existing law with regard to the appropriate or the users, the holder of the water rights intent in using water. So without going too far into that, that's sort of, at least where I'll sort of be coming from initially when we start digging into these things in this group, and I look forward to it.
Thanks a lot, Peter. Next, I'm going to go to Adam Reeves. Adam, can you please introduce yourself?
Hi, my name is Adam Reeves. I'm a water lawyer practicing principally in Division 7 in the oft-forgotten southwest corner of the state. Down here, I represent municipal, industrial, ag, as well as tribal clients. Because this is an area of the state that has limited resources, it has tended to develop more slowly. As a result, our conditional rights, including quite large conditional rights, are often perfected on a time frame that's very different from other parts of the state. Often things that could be done in a decade on the front take 5 decades down here, and over time, rights that may have looked speculative at various points in their history ended up being perfected, and being perfected consistent with their original decrees. So I'm here principally because I want to make sure that we don't adopt a one-size-fits-all response to how we treat conditional rights in particular, recognizing that the existing law provides reality checks, and that we don't assume all rights need to be developed on a particular time frame in order to be valid and not speculative.
Great. Thanks, Adam. And it was somewhat validating to hear you use the term oft-forgotten southwest corner of the state, because as the DNR group was working together to identify people, one eye kept going down to the southwest part of the state and recognizing the importance of having someone from that part. So thank you for that. Next, I want Steve Lenhart to please introduce yourself.
Thank you, Kevin. I'm Steve Lenhart. I'm a lawyer with Burns, Spiga & Will in suburban Denver. I've been practicing water law for 35 years now, and all of it in private practice, representing both public and private clients all around the state. One of my long-term clients is the Southeastern Colorado Water Conservancy District. And among other things, I represented Southeastern in the High Plains A&M case about 15 years ago that extended or clarified the application of the anti-speculation doctrine to changes of water rights, which High Plains and some others had questioned up until that point. I think that was one of the key steps, at least during the last 30 years, in strengthening the anti-speculation doctrine. And we have a doctrine that's pretty strong right now. I'm interested in seeing what people's ideas are for further strengthening it, and as some others have said, striking the right balance that still allows enough flexibility in water law, still allows a role for water markets in the state, which I think are part of what keeps water in beneficial use. The issue of speculation, as defined in the High Plains and other anti-speculation cases, is that it's really the antithesis of beneficial use. And I think if we can keep a focus on beneficial use in this group, that'll be important to defining what an appropriate strengthening of the anti-speculation doctrine will be. So I'd like to thank Kevin and Scott and Director Gibbs and others who've been involved in putting this group together. I'm very impressed with the group and look forward to working with you all.
Thanks a lot, Steve. I appreciate that. And if you noticed, I went through our legal group, our attorneys as a group, and I'd like to point out that next is the group of water users, and it's so important to have that perspective and those views and concerns. And some of them are also attorneys, by the way, but let's just go through that group. And I want to start with Joe Bernal. Joe? And if I caught Joe by surprise, I can certainly come back to him.
Joe, you might be on mute.
Do we need to unmute Joe from here?
He might have dropped off. We can make sure we come back to Joe pretty quickly here.
Okay.
If you want to keep going, Kevin.
Thanks for keeping an eye on that, Amy. How about Darius Jutton? Darius, would you like to jump in?
Can you hear me, Kevin?
You bet. Yeah, thanks.
Okay, well, I'm Darius Jutton. I'm a 5th generation rancher in the Uncompahgre Valley. Anyway, I hope I can bring some stuff to this group. Thank you for inviting me to join this group, Kevin. I'm an irrigator, and with the Uncompahgre Valley water users within that system. I'm also a board member of the Uncompahgre water users. I also irrigate with priority water rights in the upper Uncompahgre River. I'm kind of interested to see what, I guess my biggest deal is I want to see what this is going to do with, as far as property rights and stuff. And, I want to keep the land value prices where they are, but I also don't want to see buy and dry. Anyway, I think this will be interesting.
Thanks a lot, Darius. That's interesting to hear. Thank you. Next up, Joe Frank.
Hello, everyone. Joe Frank. I'm the general manager of the Lower South Platte Water Conservancy District. And I'm excited to be a part of this group. I've talked to Kevin and Amy a little bit about this. I definitely have a lot of unanswered questions, so I'm looking forward to kind of digging into existing statutes, what's on the books, some of the reasoning behind this. And, as Peter was mentioning, investment groups, down here on the Lower South Platte, we do see a lot within the South Platte Basin of entities buying up water rights with the intent to dry them up in the future. Definitely something we are working, on different options along those lines to be an option both for municipal interests and farmers. But in addition to that, we do have, those who want to sell. So water is a property right, and as Alex was mentioning, that is, something that we run into all the time, and it is a dilemma. But we don't, want to impact people's property rights. So I'm really interested in looking at, what's on the existing books and how these potential changes would or could impact existing property rights and just existing water rights in general. Any changes to impact, those folks' water rights that they have on the book. So I've heard examples of, okay, if someone comes down and offers twice as much for the water and they're going to buy it up, with the intent to dry that ground up. But a farmer, you know, can only sell it for half as much locally. How are these changes going to impact that? So I'm definitely interested to see, you know, where this goes. And like I said, I still have a lot of unanswered questions, and hope I can add value to this discussion.
Thanks a lot, Joe. I'm sure you will. Next, I want to go to Larry Cleaver. We're just crisscrossing the state, and we're going to bounce back to the west. Larry. Ooh, I saw Larry earlier. Oh, there you are. Larry, is that you that's on now?
Kevin?
Yeah. This
is Joe Bernal again. I had to switch my my electronic device, so I'm unmuted now. Is it okay if I introduce myself now?
Absolutely. Thanks, Joe.
Thank you all for inviting me to participate in this group. My name is Joe Bernal. I'm a fourth generation farmer in the Grand Valley. My great-grandpa arrived here in 1925, and my son is farming with me now, and we hope to continue. I'm also the president of the Grand Valley Water Users Association. I've been on the board for about 15 years. So Mark Harris, our manager, is doing a wonderful job of keeping us involved and aware of these issues and keeping us at the forefront. We've had the Conserved Consumptive Use program in 2017, of which we were participants in, where we did some water banking in a program that was experimental. And we've also done a study called Beyond Consumptive Use to find out why here, why now, why us. And so I believe that we're informed, but I also feel that we as producers and landowners and water rights holders are in the middle of this tug of war. And I appreciate that the group has asked me to be a participant so that our perspectives hopefully can be shared with all of you.
Sorry, muted myself. Thanks, Joe. I'm glad you were able to make it back on.
Thank you.
I'll go back. Larry Cleaver, are you there for us? Okay. Let's, Larry, I hope you're standing by and we can get you eventually. I want to move to Alex Davis.
Thanks, Kevin. I'm just making sure I'm unmuted. And first, let me say how delightful it is to see so many people who I've been able to work with over the years and haven't been able to see at all over the past 8 months. So thank you for inviting me. Thank you, Dan and Kevin and Amy, for including me in this process. It should be really interesting. And it's been so interesting to hear the different reasons why people are here. Oh, so first let me say a little background for people I don't know. I am the Deputy Director for Water Resources at the Aurora Water Department. The Water Resources Division is charged with acquiring, protecting, and maintaining the water rights for our citizens for now and into the future. We currently have about 380,000 citizens in the city of Aurora. It's the third largest city in Colorado. We expect it to grow potentially by 2070 to just under 1 million people. It could, depending on growth trends, but will certainly be growing dramatically. We are only 1/3 built out in terms of the area that Aurora has within the city boundaries. So we are a growing city. Aurora started its own water rights program in the 1950s. Before 1950s, it was served by Denver Water. So Aurora came to the game a little late, and Aurora spends significant resources acquiring water. My other background before I came to Aurora, I spent 20 years in different positions with the state, first as a water rights attorney, and then with the executive director's office, and then with Parks and Wildlife. So I've been really fortunate to see water through very different lenses of law, policy, and now management. I am super interested in this subject. I think a couple of the areas that we haven't touched on yet as a group, so we've talked about property rights, we've talked about flexibility and how do you have a program that allows for uses. We've talked about conditional water rights. One of the things that speculation brings to mind for me is price and end use, and that speculators, well, the law talks about the actual use and whether you can put water to use, but speculators, to me, are acquiring water not because they intend to use it for the long term, but because they want to make money. They want to make a significant profit when they flip it to the ultimate end user. And I think as a state, it's important to look at what one of our most precious natural resources is costing the citizens, whether it's the citizens who are acquiring drinking water, whether it's new farmers who want to get into agriculture. What is the cost of that resource, and where does the money associated with that resource flow to? Is it staying in the communities, or is it flowing out of the state? So that's one thing I'm really interested in exploring in the terms of anti-speculation, because I think that's the only place where Colorado water law might address those issues. And the idea that water is a resource of the people as well as of the individual. And so how do you strike that balance where individuals use or benefit from this resource, but because it's a resource of the people and is necessary to all life, it's important to make sure that it's available to everyone. So I think it's a really interesting challenge we have. I'm so glad Steve brought up the High Plains case, because I think that was one of my last cases at the Attorney General's office. I also got to litigate that case, and it was very interesting and significant. So I think that we have an opportunity to really explore some boundaries here around the most important resource we have as a state, in a time when we are distinctly feeling the pinch of that resource and what happened and what may be happening in terms of climate change and water availability going forward. So I'll stop there. Thanks.
Thanks a lot, Alex. Great comments. Next, I'll move to Drew Peternell.
Thanks, Kevin. My name is Drew Peternell. I am the director of the Colorado Water Program for Trout Unlimited. TU is a nonprofit fisheries conservation organization. We're concerned with river health and stream flow across the state. I've got a staff of about 10 folks who work for me around the state, doing projects that are aimed at improving river health. I'm also a licensed attorney, and I have some experience litigating the anti-speculation doctrine. I was involved in a couple cases, 10 years ago, I guess, that hinged on that doctrine. And I'm interested in how this conversation and how these issues impact stream flow, how they impact river health. I'm also really interested in the intersection of this anti-speculation issue with demand management, which is something that we at Trout Unlimited are supportive of. So really appreciate the invitation to be here, and I'm looking forward to the conversation.
Thanks, Drew. Glad you're here.
Thank you.
Next, and we're getting close to the end, but next is Kate Ryan. Kate.
Thanks, Kevin. I am Senior Staff Attorney for the Colorado Water Trust, and I really like that we fall in the category of water users. The Water Trust itself does not use water for the environment, but our mission is to restore water to Colorado's rivers in need. And so we typically partner with the CWCB in acquisitions of water to fulfill that mission for restoring water to rivers in need. I like being considered a water user. I also have about 15 years of practice under me as a private water attorney and with the Attorney General's office. But right now, I think my important role with this group is going to be representing what we at the Colorado Water Trust do, which is really focusing on transactions. And some of those water rights transactions are temporary, some of them are permanent, and a lot of them involve water sharing agreements with agricultural and municipal water users. So I think I can bring that to the table. Another perspective that the Water Trust has as a water user, I think it's really interesting for this group, is we're pretty junior in the line of water users in Colorado. It's only been since 1973 that CWCB had an in-stream flow program and a water rights acquisition program. And so we are still actively involved in looking for ways to use water for in-stream flow. And so as a junior water user, we have a very different perspective. I also wanted to mention, I think it's really interesting, my first exposure to the anti-speculation doctrine was about 15 years ago when I was in law school in California, and we worked on a law review article that looked at appropriation as agrarianism, which is really interesting. I think the concept is water in Colorado can be something that is available for use by many different people because of our system of appropriation and our system of water rights changes. And so it's something that can be very fair, and it was very fair at the outset to agricultural water users. And that article actually became part of a Colorado Supreme Court case that followed High Plains, building on the anti-speculation doctrine in the series of Pagosa water users cases. So anyway, looking forward to participating. Thank you.
Thanks, Kate. Thank you, Kate. And I just want to take a chance one more time. Larry Cleaver, are you able to get on? I see your name on the list.
Okay, Kev, can you hear me now?
You bet. Sure can, Larry. Great.
Okay, I'm Larry Cleaver. I'm the general manager of the Ute Water Conservancy District. We serve about 85,000 people in the Grand Valley. I hope to bring a user perspective from the domestic side. I also spent 17 years on the Groundwater Commission, and we saw a lot of what might be speculation while I was sitting there, and I think it'll be really interesting for me to try to blend the two.
Great.
Other than that,
thanks a lot.
I'm enjoying being here.
Thanks, Larry. And with that, I just want to pause. And Amy, we really had high hopes that maybe we could get a couple of the sponsors or legislators on. And I'm looking at the list. They're very busy. I don't think we were able to do that, were we?
I don't believe so. We did reach out to our bill sponsors to invite them to this meeting and have kept them informed as we have been getting this process up and running. But I think I do want to pause and just make sure that we didn't miss anyone or any of our bill sponsors that would like to address the group. All right, Kevin and Scott, should we keep moving?
Yeah, let's keep moving. And again, I sure appreciate the time you all spent on that. I said I didn't want an icebreaker, and you definitely gave us something of substance. It's really helpful as we move ahead. Thank you for taking the time to do that. I just took the agenda down, but the second item on the agenda, the statutory objective of the work group. And I think that's just a great obviously a great topic, because what are we all doing here? What is the scope of what we're doing? And Scott Steinbrecher has put some information together that I think will be great to brief us as we embark on what we're doing for the next 10 to 12 months. So Scott, could I bounce that over to you and go through some of that, the statutory objective of what we're doing?
Of course, Kevin. Thank you. And for the group, Kevin and I thought it would be helpful to sort of ground ourselves in what the legislation really requires. And I'm so pleased listening to what everyone has said already today about why this is important. It's obvious that people have really started thinking about what the purpose of the legislation and the work group is. But nonetheless, I want to sort of run through what is apparent to us as the purpose here. Several folks have talked about the sponsors. I want to name them in particular. It was Senator Donovan and Senator Quorum, as well as Representatives Roberts and Catlin, who sponsored the bill. Primarily, I think most important to talk about today, the bill requires the Executive Director of DNR, Dan Gibbs, to convene a work group to explore ways to strengthen current anti-speculation law, and then requires my office to support the work group. Talks about who should be named and says that then the work group should submit a written report to the Water Resources Review Committee next August. So I think one of our first tasks will be to look at current law. And as all of you know, but I'll tell you anyway, under current law, a new appropriation or a change of an existing right can't be based on speculation. And we have a few ways of figuring out whether an appropriation or a change is speculative. One is when the applicant doesn't have an interest or an expectation of procuring an interest in the lands that will be served. But of course, we have the government agency exception that allows some flexibility there. And the other way we look at speculation is when the applicant doesn't have a specific plan, an intent to divert or store and control the water for specific beneficial uses. So that's really where we're starting, and we'll spend some time later today talking about how we put together a report to explain in detail that baseline and the current status of the law where we're starting from. And it's been interesting, Kevin and I have had this conversation as we started forming the work group. As we saw this bill develop and we heard some initial reactions, I think a lot of people, or some people, said, geez, this report should really write itself. Existing law is strong and well developed. Buying land and water rights and leasing them back to farmers for continued use under their decreed terms isn't speculative, even if someone intends to use the water like an investment. But as we look more closely and as we listen to what the bill sponsors have said publicly, I think it's really clear that the PERP law can be strengthened to prevent such investments. And I want to summarize what Senator Donovan said in a recent article in the Gazette. She said that water speculators aren't in the business of using water. They're in the business of owning the water for future times when they can sell it. And that's why you see hedge funds coming into the state and buying water in a portfolio. That's what's concerning me. And she said in the article that the purpose of this bill was to make sure that Colorado's water speculation law has enough legal teeth to go after any speculative behavior. And I think Alex Davis noted some similar issues in her comments earlier. And then recently, I listened in on a forum that the Colorado River District put together to talk about this issue, and Representative Catlin was there. He echoed many of the same sentiments that I just read from Senator Donovan, and pointed out, as some of you have this morning, that even when someone is leasing water back for irrigation under the terms of the decree, that money is headed out of state, and that was of concern to him. So that's really, I think that has served as confirmation for myself and for Kevin that we really are charged with exploring how the law can be changed to address this issue, and I think addressing some of the balance that you all have talked about this morning. And I also want to point out that Senator Donovan has remarked that the purpose of this work group isn't really to make decisions about public policy, but to conduct a technical examination and report on ways to resolve the public policy issue that these legislators have already identified. And whether to implement any of them will ultimately be policy decisions for the Water Resources Review Committee and other legislators to make. With that said, though, this group, I think, is in the best position to identify costs and benefits of whatever solutions or recommendations this group comes up with, and to help those policymakers find the balance that so many of you have mentioned this morning. And I think that's where the real struggle and the hard work for this group will lie. So with that, I will turn it back to Kevin to talk a little bit about the work plan.
Thanks a lot, Scott. And, you know, this is maybe part of the meeting that I've really anticipated, maybe a little bit with trepidation too, because here's where we get to dive in somewhat as a work group and start working together already. But I want to warn you that as Scott and I worked on this item on the agenda, we were a little fearful that if we just gave you a blank screen to start drafting thoughts and ideas, it was just too much to put on us in our first meeting in a large group by Zoom. And at the same time, if we put some draft information up for you, it looks like we're trying to do the work group's work for them. And so please be aware that we did our best to put some starter information together. This is wide open to editing. It's to get our thoughts going, but it really is about, we are a work group now. We have a deliverable that's due in August of 2021. What is that deliverable going to look like, and how are we going to get there? So that's, again, Scott and I put our heads together to the extent that it would be helpful to the group to get off to a head start and put some information down for us to consider. I want to just make one comment, let you know, Tracy earlier when she introduced herself said she was also going to be, so to speak, drafting the report. And certainly it's, as I just said, up to the group to create a report, but we need one central person that's going to understand this and take everything in to start on that group, on that report and that structure. So I've asked Tracy to do that. The group has asked Tracy to do that, and she will be working hard as we go to capture things. With that, I'm going to share a draft, a draft report structure and a draft work plan. And again, this is where I would like for us to start thinking as a group or working as a group, and we can make some preliminary comments on this. And let's see, Amy, do we have that up on the screen, the draft report structure?
Yes.
Okay. First question, I struggle with this sometimes on all your various devices. Are you able to read the text okay, or shall I make that a little larger?
Would you mind making it a little larger? I'm on a laptop.
Absolutely. I think I'm just going to just do it with the font and give us a little bit larger font. How's that for people? Better?
Good.
Okay, very good. Thanks, everyone. Now, again, this is Scott and I putting something together for us to consider. I would like to review it and get some preliminary comments today, and then we will, based on those preliminary comments, send this out to the group for consideration over the next week or two. Again, this is sort of our roadmap going forward, and it will be important to get it right. But let me just go through this quickly. What is the structure of this report? We always like to start a report with an introduction and an executive summary. And one important thing, and I'm surprised we've gotten this far into the meeting without talking about this, but one important component of everything that we're doing, I think, is a strong foundational understanding of the anti-speculation doctrine, anti-speculation law, what it is in Colorado, because I think we all have our own understanding of it. But I think we need, as part of our report and for the Water Resources Review Committee and the public, to have that well documented by this group. And so that's probably the second, and what ends up being the first substantive item in the report, is that factual and historical background of our anti-speculation doctrine. Probably put a few bullets in there to give that some structure. And Scott, I think now would maybe be a good time to jump ahead and say that we want to name a subcommittee, a legal research subcommittee, to do that work. Do you want to say anything about that now, or do you want to get to it in a few minutes?
Let's keep working through the report structure. Kevin, I think it's fine to say that for folks to start thinking about whether they would want to volunteer to join that subcommittee, I think our first task will be to establish that foundation of current law, and we'd be asking anyone who's interested to participate. I'd like to get at least 5 folks, but I don't think that there's any limit on who can be involved in that first subcommittee to sort of start the report for us. Great. Okay, so continue looking at that work group as I move ahead. The third item would be, what are Colorado's current risks? And that's such a broad, such a general statement when I say Colorado's current risks. But for the currently defined understanding of speculation, and for other actions that in general terms are seen as speculative. So I said earlier that we'd be revisiting some of the work group's comments soon. And I think A and B are a good reflection of that, of many of your comments. We have our current understanding of speculation, but we have other concerns out there. So what are Colorado's current risks? And that's why I'm so happy to have this diverse work group from across the state and different uses. That would be our third task. And I think that'll be a lot of work and time spent for our work group. Number 4, of those risks, yes.
First question, do you want some questions and comments as we go, or do you want to walk through the whole thing and then are you going to open up for discussion?
Both or either. I'll tell you what, Alex, let me name off 4 and 5, and then let's just open it up for all of this. Is that good?
Perfect.
Okay. So the 4th item, and this is just really progressing sequentially. That's why I feel it was okay to do a little work ahead of time. Of those risks that we've identified in number 3, how should our body of anti-speculation law, current or proposed, protect us from those risks? And I suppose inherent in that question is also not only how should it, but just should it? So does our current body of law already protect us? And if new laws are needed, quite frankly, it's important to ask, are they compatible with our Constitution and other property rights laws? I heard a couple comments about that earlier from work group members. Finally, number 5, this is what the report is about, a recommendation to the Water Resources Review Committee on how to strengthen current water anti-speculation law. So with that, Alex, I'm sorry I just put you off so quickly, but now that we've gotten a look at all of that, any comments, Alex?
Yeah, no, my first thought was that B1 is, I guess it's 2B1, the purpose and basis, not only in the Constitution, but having a really clear definition of what speculation is under current law. As Scott was explaining, the intent of the Senate bill that we're operating under may be looking at it slightly differently than it has been in the past. So, we use this word speculation, and I think we need to all really know what we mean when we're saying speculation and thus anti-speculation. So maybe having, a clear definition of what it currently means, a definition of what is referred to in the law that we're charged under, and then maybe where we want to go. Like, do we want to change that definition? That would be helpful to me.
Okay, great, thanks. What other comments? This is very general, but it's a lot of information to process, and we'll, like I said, we'll certainly have time later to for you to review it.
Kevin, I have a couple of comments, if it's okay.
Please.
I'm muted. I think I'm unmuted. When I saw this bill, one of my concerns, and I'd be curious if some of the other folks on the line have had some of the same experience, is that some of my clients have already taken actions to preclude what they viewed as speculation that would harm the area, where their water is. So the example I give is the Northern District declined to approve using the discretion it's given under the Water Conservancy Act, some water transfers, because they thought it would harm the area. And those were challenged. There's been some litigation around those. And so what I don't want is for this report or future actions by the legislature to take away that discretion or to kind of undo the protections they've already put in place. And if anything, I'd like to see this supported so that if it gets appealed, one of these gets appealed to the Colorado Supreme Court, there's law there to support the actions that have already been taken to protect the local economy under, at least in that case, the organic statute for that entity. I don't know other people's organic statutes well enough to know. Peter, if yours for the River District has that kind of authority, or others who've worked, Steve Lenhart maybe has some thoughts about that. So I think it would be helpful for us to look at, okay, what tools are already out there and how do we either maintain those tools or at least not undercut them at the local level. The other question I would have, and maybe this conflicts a little bit with what Alex was talking about, I think speculation is one of those things that can be viewed differently with a different lens. And Adam Reeves kind of alluded to this. What might look speculative in Aurora might not look speculative in La Plata County at all, because it might take 30 years to build something, whereas in Aurora, they have more financial capacity or other more shorter term needs. So I'm not so sure that spending a lot of time trying to come up with a statewide definition of speculation is even possible. So do we want a law that allows on a more local level instead of a statewide level, a tool to prevent speculation? And I put that question out there for folks to think about.
Peggy,
I have a thought, Peggy. I'm sorry.
No, please, Alex, go ahead.
I don't know if we're supposed to raise our hand, or I don't know how.
I think our group is small enough that just jump right in.
Because I appreciate, Peggy, what you're saying is, what does speculation mean, and how do you define it, and what does it look like? And the distinction you just raised is a temporal distinction. So that distinction to me is easy to make in terms of, if you're trying to determine whether an action is speculative, what I hear you and Adam saying is time may not be a good metric to determine whether an action is speculative or not. But I wouldn't want that idea that certain metrics are harder or different to apply to prevent us from, at least as a group, having some common terms that we all know what we're talking about when we say speculation. Because I already heard a lot about conditional water rights, and I hadn't even considered conditional water rights being speculative. To me, they're conditional water right, they're decreed. So people who are thinking about speculation in the context of conditional water rights are already thinking differently than I am, so that's helpful to understand, right? That's really important for me to understand that that's a problem and a concern. So I would vote for trying to have some clear, at least parameters around what speculation is. What are we talking about here?
Thanks, Alex. If I could just jump in real quick. Peggy, I was going to, maybe in a similar way, add a sub-bullet under 2B1 and ask the question, how rigidly should we apply the standards? Because that's a little bit what I heard from Adam. What may look speculative in Aurora may not be speculative in the southwest part of the state, but it's more of a timing thing. But I'm thinking maybe that's a great detail, and we may see an opening for that down below, but I'll just leave it at that.
Hey, Kevin, this is Alex. I have a question, comment. I guess on number 5, in terms of the recommendations piece, I guess I just have a general question about the size of the sandbox we're playing in. So obviously we're looking at, like, potentially changes to anti-speculation law, but, kind of listening to some of the comments that were made by the sponsors of this legislation, it seems like buy and dry is a major concern. There's sort of this, like, these community, like, socioeconomic impacts of drying up ag. I mean, sort of, any recommendations that would go beyond anti-speculation to, like, maybe address some of these, like, broader system concerns, or is that really beyond the scope of this work group? And just as one example, like, would we make a recommendation that says, alternative transfer methods are a good way to maybe mitigate some of these impacts? Anyway, hopefully this makes sense. I'm just trying to get a sense of, like, where I should be focusing my thoughts and energy around this work group process.
Yeah, I think, well, that's a great question, Alex. And I was following the direction you were going. Do you think, would it be fair to summarize that outside of anti-speculation laws, are there other mechanisms that can mitigate speculative effort or the risk of speculative efforts?
Yeah, basically, like, minimize the impacts. I mean, say this process is legal under current law, are there other tools or approaches we could use to minimize any sort of socioeconomic impacts to regions that are still, heavily agricultural based, in ways that don't have anything? Hopefully that question makes sense, because I wouldn't, and if it's not appropriate, that's fine. It's trying to get a sense of, like, whether those are things we want to touch on as part of this process.
Well, thanks for bringing it up. Scott, do you have any thoughts on that?
Yeah, thanks, Kevin. I think some of this will have to be determined by the group as we go, but I could see some of these being parallel to what Peggy was mentioning earlier, that we need to understand what tools we have already and how those can be incorporated into the report and recommendations. So without trying to oversimplify too much, Alex, I think it will just depend on what it is we're talking about, but we should be aware of whatever tools we have and include those in our analysis.
Okay, thanks.
Yeah. What other preliminary thoughts do you all have? Because, again, you will get this sent to you soliciting more comments after you've had time to really process it.
I had a question for Peggy. I was wondering if her comments on Water Conservancy District with its existing legal authority were dealing with basically restrictions on project water using the district's own water rights versus restrictions on the water rights of others within the district.
It's project water rights. So yeah, the board can deny a transfer of project water from one water user to another in their discretion. And they've done that. And they in fact adopted a rule, I can't remember the name of the rule right now, parking and storage agreement rule it's called. You can see it on the Northern website. And they've done that and been challenged in the district court for having done it. That's one thought. Two other thoughts while I'm talking is we still have an anti-export law on the books, at least last time I looked. Do we even want to think about that? There have been law review articles written about how valid it is and questioning it. And in addition to having investment groups come into the state to buy up water rights within the state, I suppose at some point, the export of the water for outstate use might come within the purview of this. But Steve, getting back to your question, I think a bigger bite would be, could there be any local authority over local water supplies? Does that so run afoul of people's notions of private property interests that we don't want to go there?
Which kind of intersects with 1041 issues as well.
Yes, that lovely 1041. I know it well. Right.
Yes, you do. Other comments, please.
I would build on what Peggy and Steve are saying. I was thinking about for 4B, we have, if new laws are needed, are they compatible with the Constitution? So I think I would add either add to 4B or add a 4C. If new laws are needed, are they compatible with Colorado state laws? Because I'm thinking there probably are things where there could be things beyond the anti-export statute and 1041 permitting that we haven't thought of. So doing a survey there.
I guess.
And then.
So it doesn't sound circular.
In the context of the compatibility with other laws, leaving the Constitution out because that's a little more difficult to change, I wouldn't want the answer to be, no, this idea is not compatible with state law, and so therefore we can't talk about it. I think it's important to explore anything and everything that, and if it is incompatible with state law, then there might be a recommendation to change that state law. So it shouldn't, so I just wanted to make that idea that just because it's incompatible doesn't mean we shouldn't discuss.
Yeah.
That's a good point, Alex, and I think well within our charge.
Well, I guess while we're at it, I would probably add the federal Constitution to that. I mean, you can kind of see right off the bat that, if it concerns out-of-state interests, we could be talking about dormant commerce clause issues, we could talk about takings issues. I just want to be, I guess, expansive that we're covering all of our bases in these new proposals.
Let me just say as a placeholder, any and all probably not the best wording right now. We can't change federal law, I guess, so maybe I want to back off from that generalization there.
Well, while we're talking about changing state law, I have another idea. Those of us who've been around a while have scars from cases we've lost. And one of the ones that I and I mentioned this to Scott when he called me, is that the way our water court statute is now written, any person allows, according to legislative testimony, and trying to remember, it was Jennifer Berman in legislative drafting who at a Senate committee hearing said yes, that she believed that the way our water cases are, that any person means any entity from anywhere can come in to challenge a water user in Colorado court. And I was arguing that it was limited. So the example I gave was if the city of Las Vegas wanted to come and challenge all of the conditional water rights in Colorado can and will, they could bring their financial wherewithal to bear and defeat a lot of Colorado water rights. And the answer to that is yes, they can. You in fact are wrong. I've always thought we should at least think about that. Do we really want to allow that to happen? But that's in legislative testimony and apparently the way legislative counsel views that statute. So do we think that's part of the charge here? Maybe closing that door to some degree? I ask the question and see what people think.
Some of this, I think, is giving us a head start on our future work too. And not that I don't appreciate it, Peggy. I'm keeping track of it. But does that make sense where I put that, Peggy?
You know, I'm trying to look at you and I'm not paying attention to the cursor. Oh, there you go. Sure. I don't think it matters where it goes at all.
Yeah, good placeholder. Okay.
Yeah, I don't care where it goes. I'd be interested in seeing what people think about that.
Now I do, so I'll reiterate, this is not your last chance to see this. This is just our initial cut with you seeing it at the first time. If you'd like, I can scroll down to the next section where Scott and I have put together a draft work plan. And of course, some of that overlaps. But shall I move down to that, or do you have any more comments on the structure?
Evan, this is Peter. This is a great conversation. I really appreciate it. And again, in the structure of the outline, I guess the more we poke at this and add to this, we're getting into more substantive work. So if we don't want to address my comment here, that's fine. But part of speculation, and well, an important part, goes to the intent, the appropriator's intent, the owner's intent as to how they are going to use the water. And even the anti-speculation statute, I think, talks about intent as evidenced by, a couple of examples that I think Scott read previously. So I guess one thing that we might look at is what are other ways other than, what the statute already provides to either demonstrate intent or to get behind what the actual intent is. I think we'll all look at the law and pretty readily agree that that the law allows you to appropriate water for use, not for profit, not for just a pure profit motive. You're allowed to profit from your use, obviously, but you can't have profit is not the end goal of the the pure value of the water. So how do you get into looking into what the intent of the appropriator, whether appropriating new water rights, changing a water right, as Alex and Steve pointed out in the High Plains case, or in the holding of the water right, that whether it's conditional or absolute. But again, that might be getting too much into the actual work, but I think that's going to come up pretty quickly.
Well, yeah, and again, Peter, I appreciate it because it's moving ahead, but I think it it helps me understand how to make sure this report structure accommodates all these different thoughts. So I appreciate it.
I would just add, I think that's so, I think that's hugely important. And it goes directly to what Aurora struggles with around acquiring water, because we know that people buy water from farmers. They may be able to farm with it, but their intent is to flip it to the city and make a profit on just the acquisition and the transfer. And to me, that's a big part of the anti-speculation intent, but I'm not sure that, but it seems to me that that is one of the areas where the senators and representatives who passed this law have seen there's all sorts of ways to get around that, right? Because you buy the water, you keep it in farming for a couple of years, jack up the price, and you sell it to the city. And you walk away with your profit, but you haven't broken any laws. You haven't breached the anti-speculation doctrine in that context. So I think Peter's point is important.
Absolutely.
It seems that what you guys are all getting at is that the legislators were looking at not a new appropriation or change of water, right? Those things that are decreed by the water court, but really the transaction itself. What was the intent with the transaction? And so when we're talking about water law, really we need to maybe be digging into considerations with that transaction.
Well, I think it's it could be the transaction, but it's what the new owner's actual intent is, regardless of the seller. I mean, seller could be a farmer who's farmed for 20 years or 100 years, and the family decided that unfortunately the kids don't want to be in the business anymore, and it's time to sell and move to Arizona. They're entitled to do that. And so you don't want to, I assume we don't want to prevent that from happening. I think Alex Funk talked about that previously. But the buyer, it could be a completely clean transaction, but it's the intent behind the buyer that I think is the important thing to look at there. And that might be evidence in the transaction. So I'm not saying don't look at the transaction, Tracy. I'm just saying it's more on the actual new owner, I suppose.
Yeah, and my point was pretty much that new owner probably doesn't even have to go to water court to do what they're trying to do.
So I have a question. This is just a fundamental question in my mind. If Alex and Aurora came over to the West Slope and bought up a bunch of new water rights, or a bunch of existing water rights on the West Slope, and put them to beneficial use for 10, 20 years, and then changed that and moved it to municipal use and brought it back over the hill, would there be the same view on that versus an investment group kind of doing this as a middleman, doing the same thing?
No one should ever be able to do that, Joe. Of course, I'm joking. No, because that would go through a normal change of use case, and there would be, the opportunity to get in the case and determine how much they were entitled to take. And, in my mind, at least, so long as Aurora was able to demonstrate that they had a use for the water within their, service area, within their boundaries, you can do that. Doesn't mean it wouldn't be contested as any, change case can be. But I don't see that as speculation. I see that as part of their growth and their acquisition of water for their own purposes. What doesn't make us happy, but.
But I would assume that whatever investment group purchased that water would at some point sell it to a municipality or have an end contract, which at that time in the change case would have a beneficial
Yeah, sure,
use.
and that has happened in the past. Probably, well, yeah, definitely on the west slope, as well as obviously in the South Platte and Arkansas River basins as well, where water has been acquired by investors and then sold to municipalities, who later changed the water right, or actually the investor may have at one time changed the water right. Just so happens in the High Plains case that, you know, they didn't have a contract with an end user. And so the objectors were able to show, you know, you don't have any current intent in order to change this. You have to have a current intent yourself or a contract with somebody that does. So if you don't, if in the example you gave, Joe, the at least in my read, if the investment group did not have a current contract with Aurora or some other end user of water,
right.
They certainly couldn't change the water right for that purpose. I think the question that maybe the you know, the legislators that sponsored the bill were concerned about was, should they be able to even acquire and hold the water right before they go to the change, before they get a contract, if they don't have an actual end use in mind at the time. And in my mind, at least, you know, I think the High Plains case, the logical extension of that could be that, no, you shouldn't be able to do that.
Let me just make a quick comment.
I'm sorry, Kevin, can I just say one thing in response to Joe's hypothetical? Because I think, to me, it's one of the nuts of what we're talking about. So municipal use in the state of Colorado is an important use for the state, right? We all want clean drinking water every day. And so anti-speculation, as it applies to cities, is different for that reason. Cities are allowed to acquire water they're not putting directly to use today, because we know we're going to grow, there's going to be needs in the future. And I hope that our conversation isn't about pitting agriculture versus municipalities, because to me, the conversation is about how do we keep water being used to its highest purpose, whatever that purpose is, in the state of Colorado, and maintaining the benefits in Colorado. And I don't want to sound too protectionist, but it's this issue of, if Aurora has an opportunity to buy a water right from a farmer at $10,000 an acre foot, versus we could buy it from a broker at $15,000 an acre foot. The farmer still gets the 10, the $5,000 per acre foot is paid for by the citizens of Aurora. We are a nonprofit entity. We don't make any profit. We charge our users what we pay. And that $5,000 per acre foot then goes to Florida or, you know, wherever the investor lays, and it's out of our economy. Is that to me, that's one of the issues that that Colorado is facing, that our citizens pay more, our farmers get less, because the water's not going anywhere. You know, if someone from New York invests in water in Colorado, that water is only going to farming industry or municipalities in Colorado. It's not going to go anywhere else, right? It's unless Peggy's vision comes true, where which, you know, then it would go downstream. So we're really talking about what is the impact of the transaction. I think Tracy was on point with it. Part of that is that transaction and who benefits and where do those benefits go. So I will try not to get on that platform too much, but I just think that's one of the nuts that we're struggling with here.
I think it's a good comment, and these are all good comments, and I get a lot of satisfaction out of seeing that we picked the right people for this work group, because we've already done a lot of our work for the second and third meeting today with our great conversation, and of course we get to do that. But I think we're doing a great job of identifying the importance or emphasizing the importance of this foundational work. What does our current water anti-speculation law do? How does it lend itself to the different processes and concerns? And then what are the risks? And so we're starting to talk about those right now. I appreciate all the discussion. I want to, if I can pull us back a little bit, go through our work plan as well today and do a couple other things that we really need to make sure we do by the end of the meeting so that we are set up to continue with our work. So if there aren't any other comments about, you know, the structure itself as I look at this report, not your last chance, just this was just your initial chance. If there aren't any other initial comments right now, I'm going to scroll down to the work plan. Is that okay with everyone? And I guess I'm doing it nonetheless. So let's move ahead. And this, like I said, dovetails somewhat with what we were just talking about. More of a identification of tasks and meeting times just to keep us on schedule for August 2015. And of course, what we're doing today, I cheated a little bit because I knew what we were going to be doing anyway, but through our introductions and reviewing this report structure, we've got a plan for further input. We'll send this out to you. Same with this schedule and work plan that we're looking at right now. Today, we also need to identify the legal research subcommittee to do that second task, doing that foundational work. I would like to touch on public comment opportunities today. And then we'll just set a plan for checkpoints, how we may need to touch base with each other between now and the next meeting. Now, I really just use 2 month increments to get us started. We could compress this. We might have less regular and more regular meetings, but let's just assume right now that there would be another meeting in December 2020. And that's where we would review the preliminary results of the legal research subcommittee that has done this foundational factual work on our current anti-speculation doctrine. And then we can move into that discussion that, boy, we're all just kind of chomping at the bit today already. What are Colorado's speculation risks? You know, what are the risks? What is that risk? What are the impacts, primary and secondary? Are there pros and cons? And this got into a few people's comments right here in these Roman numerals 1 through 4. And so that would be at our next meeting, and we could begin incorporating some of that information that we're developing into a draft report. And then, as I said before, set plan for whatever checkpoints by email. You know, and what I mean by that is we may say, hey, we're going to draft up what we feel we got out of this meeting, and we're going to send it to you for comment, and we'll need to hear back. So that's what I mean by checkpoints. The next meeting, and you can see I'm basically following the report structure from above, but the next meeting that would maybe be 2 months later, assess our current information. Really, this is holding a couple things up at the light against each other. The results of that factual, foundational assessment or report on what the anti-speculation doctrine is. And then also the documented concerns that we had done in the previous meeting regarding speculation from the group. And then that's where the group can really dig in and analyze, you know, of those risks, what's already addressed, what is not addressed, and then importantly, what should be addressed. Because as we saw right now, we just saw a little bit, maybe some things should not be addressed, maybe some things should. But then, you know, Alex Funk, this is maybe you were looking ahead without me knowing it, what legal mechanisms are available to strengthen anti-speculation law. So maybe there are things outside the normal box that we think about that might be available. I hope I'm not mischaracterizing your thought there too much, but so there we are. And then I'd say when we get to April 2020 or the next meeting, maybe we have a working session and we can review a draft report and finalize it. And and discuss how it might be presented to the Water Resources Review Committee. And, you know, from here on out, I think it's very fluid what we'll be doing, but we're really finalizing a report as a group, you know, discussing how we might present it, who might present it, that sort of thing, and give ourselves time over the summer just to finalize all that work. So, you know, there's nothing really amazing at what I've put there, but certainly interested in comments, the timing, the staging of these different tasks in the meetings, any thoughts you have. And can I start out by saying one thing? As I saw this, I know that we have pretty much 10 months at this point to do that. That's a lot of time, and it's very little time at the very same time. But I began to wonder whether, in just trying to space the meetings out regularly through that duration, whether that schedule's a little elongated. Is 2 months too much time in between meetings? Maybe not between this one and the next one where the legal research subcommittee needs to do its work, but you know, that's just one item that I wondered about as I was doing that.
I don't think it's too long, Kevin. I think it's very doable. You know, I think that it works fine. There could be other ways to do it, but I don't see any fault with this. It's fine, I think.
Okay.
I always like the idea of scheduling extra meetings and then being able to cancel them if you don't need them, but having them on the schedule if you need them. So I don't know if in 2021, maybe you want to put in, you know, I can't see below February, but monthly meetings just to have them on the calendar, and then by February, the group will have a good sense of where it is and whether, you know, we need that time. But I just know, looking at this group, people are very busy and calendars fill up very quickly. And so I never mind scheduling something well ahead of time, particularly if we think it might get, you know, if we need it, it's there, and if we don't, we can cancel it.
Yeah, that's a great comment, Alex.
Just one question that could impact scheduling, I guess, which is, I think we're going to talk about this, but the public comment opportunities, I guess I'm just wondering what's contemplated there. What, I guess I just don't really have an understanding of when that is expected to take place in this process, at what points.
Oh, that's, Amy, I'm so glad you brought that question up, because I think my 1E is a little ambiguous, or could lead us in a couple directions. And the point there is, I would like the group, or we, it wasn't just me, we would like the group to consider today, at the end of the meeting, would you like the public that's also involved on this Zoom meeting to be able to make some comments, not only for the benefit of allowing them to say what's on their mind. Having said that, we don't have a step in this process to disseminate this to stakeholders for review and comment and editing and addressing. And while that sounds a little exclusive, and maybe I don't quite like it when it comes out of my mouth, the real point is Dan Gibbs and DNR did, I think, a really good job of bringing some key people together, just the right number of people, the right cross-section of people. And we're relying on that group to do its work. Was that a good response, Amy? Because I think...
Yeah, that makes complete sense. I just wanted to make sure that that wasn't something that we needed to work into this process in some way. So thanks, Kevin.
You bet. Scott, would you, or Amy Moyer, do you have anything else to say about that? I hope Hope that came out all right.
No, I don't have anything else to add there, Kevin.
And Kevin, I'll just add, as we get into the later months and leading up to August of 2021, we did want to talk with this group about public engagement strategies and opportunities to, look at a potential draft report down the road. And so we may build into this timeline those opportunities, but wanted to have that discussion with the work group. And maybe that's a conversation to tee up in December, since we have about 15 minutes left for today. But certainly the schedule is fluid and can be adjusted based on how the work group is progressing.
Yeah, thank you. Okay, well, as I said, you'll get to see this work plan and schedule as well. That's for the work group. And with that, let's continue. I would like to address one important point. Scott, a critical task for today is identifying that legal research subcommittee. And Scott, I think you have some good direction on that.
And I'm
Yeah,
sorry,
thank you.
Kevin, but can I jump in with one question for the group? I was wondering if it would make sense to also have a subcommittee to look at the risks. It seems like we started the conversation today and it's pretty nuanced and involved, and I wonder if we'll be able to, if it would make sense to have a subgroup that talks about it in the interim between now and December, so we don't come in cold on that issue in December. And if the answer is no, that's totally fine too. I just wanted to bring it up as a possibility.
Did you say to talk about the risks? A subcommittee to talk about the risks? And, I guess maybe when we talk about the schedule being fluid, maybe already we could consider that, but could we, Kate, consider our committee to be that subcommittee and maybe just meet sooner for that specific purpose? While the legal research subcommittee is doing its work in parallel?
Yeah.
Okay.
And Peggy, while Kevin's typing, I saw your comment in the chat about an opportunity for a public engagement website. And I think that's absolutely something we can look at between what's available across some of our water divisions in their online platforms and get back to the group on standing something up.
Kate, that's just, I'm not sharing my screen anymore. So as a placeholder, Kate, I added a November, December meeting, initial discussion of risk by the entire committee, but still don't get to see it, do you? There. Is that a good placeholder for that idea, Kate?
Sure. And if others don't think it's necessary, that's totally fine. I just, I feel like it would be interesting to hear more from the different water users about what they felt like the risks to their water use might be.
Let me ask about sequence. Is it okay to have an initial conversation on that before we have talked about the factual and historical foundation for anti-speculation?
Kevin, I really like the idea of getting people thinking about these issues earlier. I agree with Kate that we don't want to get flat-footed. I think folks will have to be flexible in the discussion because some of the risks we might not understand until we see what recommendations are from the group or until the report really starts to develop. But as long as people are willing to think open-mindedly and be flexible, I think it's great to start thinking about it early on.
Great. Okay. All right, let's go back. Scott, can you move ahead with the Legal Research Subcommittee?
Yes, so as I mentioned earlier, I think our first task is to put together this report on sort of the baseline of where we're starting and what existing anti-speculation law looks like. To do that, I would like to start a subcommittee to put together that report. We have some very expert attorneys in the group who have helped define what anti-speculation law is in Colorado, and I would hope that some of you would volunteer to join us. Obviously, this will have a bit of a task to put the report together before December, but the way I imagine this going is that we try to get at least 5 members involved on the subcommittee, more if other people are interested, have one meeting here very shortly within the next week or so to talk about how we want to structure the research and the report so that we're not putting this all on one member, but can hopefully attack it from various angles, and then put together a schedule so that we can deliver something to the rest of the group before our December meeting. So unless folks have questions, I may just open it up to volunteers, and if people need more time to think about whether they have the time to be involved in that subcommittee, I suppose we could set a later deadline, but I'm hoping people can volunteer for that today if they're interested.
This is where the hands shoot up in the air.
Well, I have a question. You know, you could do a 80-page diatribe on this, or you could do a 3-page summary or 1-page summary maybe. Tracy sent out Justice Hobbs' anti-speculation doctrine piece on the chat. Is it just updating something like that with whatever's happened since then? I don't have a vision for what you're looking for, and I'm not into writing a law review article at this point, but I'm happy to help if I can. So maybe a little bit more about what you're looking for and what's your target audience. I mean, writing a very lawyerly thing might not be very helpful, even though we lawyers might enjoy it.
Sure, I think your question is a good one, Peggy. I think the vision for this is that it's something functional and it serves as a foundation for our report, not as a diatribe on the existing state of the law. I mean, the purpose of this is for anyone who's reading the report, who's on the Water Resources Review Committee, to have a clear understanding of where we're starting from and what our recommendations are from there. So I don't envision it to be overly lengthy. I picture it to be functional, and the audience to be legislators who will be reviewing the report. Did I make that sound short enough for you, Peggy?
I think that's a good subcommittee mission. I will volunteer for the subcommittee. I also noticed on the chat Joe Frank nominating Justice Hobbs, and I heartily second that nomination. Also, I'm very impressed with this 2-pager from Justice Hobbs. I think it's about the only thing I've ever seen from him other than poetry that was limited to 2 pages. And if he can summarize it in 2 pages, I think our group ought to be able to do something that's equally concise and useful.
And I'm happy to help out, Peter, now that it's been substantially shortened and made easier.
And plagiarism is going to be okay?
Yeah.
Drew, did I see you volunteering? Great, thank you.
Yeah, I did add an item on that task of the Legal Research Committee. Maybe the first item on your to-do list is to determine the scope and form of the report. Just FYI.
Well, Peggy, Steve, Peter, and Drew, thank you for volunteering. If anyone else is interested, let me know soon. I will reach out to those four and to Justice Hobbs to see if he's interested. But I'll reach out to you all and we'll try to schedule a meeting pretty quickly so that we can talk about exactly what we want to do with that initial report.
And Scott, to the extent you haven't just assumed this role, I'm going to list you as the chair and the chair of the committee and coordinator of this report.
Sure, I'm happy to do that. Thanks, Kevin.
Okay. Okay. Next item on our agenda for today, we did list an item, public engagement process, and Amy, I'd like for you to be a part of this too, but you know, I made a comment earlier that it might be a little unwieldy if we tried to develop each step of our report through a large statewide stakeholder process and review. But Amy did mention that, you know, there may be milestones where we want broader involvement. So I want to open that up to the group. And Amy, if you want to maybe kick that off or remind us of maybe what you're thinking in that area too.
Sure, thanks, Kevin. And this can just be a quick tee up for more conversation as the work group gets going. But thinking about at what milestones or at what draft stages there might be benefit to allowing the general public to provide feedback. Are there targeted questions that we would want to vet with specific groups? Those are questions that, in terms of public engagement, we want to have the work group be thinking about and sort of discuss a strategy. Again, these meetings will be open to the public. We'll be, you know, recording them and offering some short summaries of what we discussed. So there will be, you know, transparency in this process, but there may be milestones or steps along the way that we would want to collect feedback in a way that the work group thinks would be helpful to the process. So we wanted to just leave some room for that discussion here.
I wonder if there's really much for the public to consider until we have a fairly final draft.
And I guess my thought is that maybe it makes sense to some extent to just play this part by ear. You know, the near final draft, I think, is one kind of point at which we might want feedback, but also, you know, as we're going, if we do, I think, Amy, as you mentioned, if we have specific targeted questions that might benefit from talking to specific people or groups, maybe we can just identify those as we go.
That sounds like a good idea, Amy.
Well, Kevin, we have just a couple minutes. Do we want to kind of close this out and go over next steps?
Yes, and so let me just make sure the one bit of homework that people are going away with, or two pieces of homework. One is this legal research subcommittee. You're going to be hearing from Scott, and you'll be tasked already this early in the game. And then also we will send out the draft report structure and draft work plan and schedule for you to take a little more time to look at and comment. And Amy, would you prefer that we just do that through a Word document and just receive individual responses?
Sure. Yep, that sounds great, Kevin. We can send a follow-up email to the group summarizing all of these steps as well.
We may be too large of a group to use a Google Doc for that, I'm thinking. So I think those are our 2 pieces of homework that we're all going away with. And other than talking about how we might schedule our next meeting date, or maybe our next 2 meeting dates, are there any other things that I'm missing there? Okay. If not, Scott, Amy, do you have any other closing comments?
So it sounds like, Kevin, we are looking to schedule a meeting in November for the work group to join to talk specifically about risks, and then a full work group agenda in December with the agenda that you've laid out so far. Is that right?
Yeah, I think so.
And so given, I know we all hate doodle polls, but given the time left, that may be the most efficient way to get those meetings on the books, and we'll try and do that pretty quickly following today.
I think it works great. I appreciate it, Amy.
And Kevin, I'd just like to thank everyone for their participation in the group generally and for the discussion today. I have really enjoyed listening to everyone, and I'm very encouraged at all the thought that people have already put into this, and I think this will be a really beneficial process. So thank you, everyone.
Yeah, thanks, Scott. I agree. Thank you, everyone, for being a part of this group and for your time today and for your investment of time in the coming months. If there's nothing else, then we'll close out our meeting.
Thank you.
Thank you.
Thank you.
Thanks,
Thanks, everyone.
everyone.
Thanks, Kevin.
Thank you. Bye.